Supreme Court Justice bails on case right after it starts. U.S. Supreme Court justices on Wednesday heard arguments in a dispute over whether a California lawyer can trademark the phrase, "Trump too small." Justice Samuel Alito seemingly bailed on his vote in the case shortly after the hearing started, saying, "You don't need my vote to win this case." Employment lawyer and progressive activist Steve Elster applied to register, "Trump too small," a reference to a crude comment that Senator Marco Rubio made about Donald Trump during the 2016 presidential debate with the Trademark Office in 2018. Elster began selling T-shirts featuring the phrase as it appears on the front of the T-shirt, with "Trump's package is too small" on the back. His application was rejected as the Trademark Office concluded that Trump's written consent would be needed, as required under a 1946 law called the Lanham Act. On Wednesday, the justices heard arguments in the agency's appeal of a lower court's decision that reversed its denial of attorney Elster's trademark application. Elster argued that his free speech rights are violated if he cannot register a trademark that criticizes a public figure. However, Supreme Court justices appeared skeptical of that claim. Shortly after the hearing began, the United States Patent and Trademark Office's lawyer argued that the case is not a question of free speech, but a condition on a government benefit or federal trademark registration. In response, Justice Alito said he won't vote just on the basis that it is a condition. He said, "If I could not vote to sustain this, without saying this is the attachment of a condition to a government benefit. I mean, you don't need my vote to win your case. Maybe you've just decided that, well, Alito is a lost cause here." Jimmy Hoover, Supreme Court reporter at the National Law Journal, shared Alito's response on X, formerly Twitter, and called attention to the challenges of the case. Alito says that's a dangerous road to go down, and Gorsuch hints USPTO can win based on long history of similar TM laws, Hoover wrote. Alito lays his cards on the table, says he won't vote to uphold the name bar simply because it's a condition on a government benefit, and asks for another theory. Time equals 400 ms. greater than. Meanwhile, Justice Neil Gorsuch noted that there is a long history of prohibitions on trademarks that reference living people, suggesting that there was no sense at the time that there was a free speech issue. "Why not just look to the history?" he said. Time equals 400 ms. greater than. Justice Sonia Sotomayor pointed out that even if Elster cannot trademark the phrase, there is nothing to stop him from selling the T-shirts, questioning whether there was any restriction on free speech in the first place. As oral arguments continue, the court looks likely to affirm the U.S. Patent and Trademark Office decision that rejected the application, according to NBC News.